2024 by a professor from the United Kingdom that about 100 lawsuits involving disputed questions of facts are decided in courts for every one case where the law is in doubt. This remark is significant for our discussion today. And I can say without fear of contradiction and even without reference to empirical information that in our country, we decide more number of cases based on more number of cases with disputed question of facts are involved than cases which requires a declaration of law or clarification of law. This point is made because it underscores the importance or the role that is played by law of evidence. Law of evidence plays an important role in this context because disputed question of facts are decided based on the evidence that is produced by the parties who are before the court. When we speak of law of evidence, it can be safely said burden of proof and standard of proof make the bulwark of this branch of law. Dr. Desai described this law as being baffling because some could describe it as substantive law, some could describe it as procedural, some both, and it is sort of mystifying. Now, if one were to look at appreciation of evidence as part of that branch of law with two bulwarks supporting, it may not be so mystifying or baffling as what I would tell you to begin with. When we speak of burden of proof, we are speaking of the burden on the person to prove a particular fact. When we speak of standard of proof, we are speaking of the quality of evidence, the kind of evidence that will have to be placed by the party. If it's a case where A is accused of killing B, and if we are speaking about burden of proof, we are trying to say who should prove the fact that the asserted fact that A has killed B. Generally speaking, it is the prosecution. Prosecution which aids investigation, which will have to prove that A indeed killed B. If it's a civil dispute, there is a fact and issue. The person who brings the fact and issue and denied by the other side is enjoined with the responsibility or the burden of establishing that fact and issue. If this is one bulwark, the other one is standard of proof. When we speak of standard of proof, we speak of two principles again. One, preponderance of probabilities, and the other, proof beyond reasonable doubt. These two concepts throw up, or principles could throw up different questions. Are these concepts different? If they are different, why so? If they are not different, then what is the interplay? Why do we say there are two principles? We could address these questions a little later, but at this point of time, I would like to make a statement and pause to ponder and request you to ponder. Of course, involving some translocation and moving back in time. We have been a civilized society, but it is also true that we have been at loggerheads with each other, leading to disputes. It's also true that we have had systems in place to decide on the disputes. I mentioned translocation and moving back in time for the reason that, as referred to by Dr. Desai, We follow the Anglo-American system. And therefore, we'll have to translocate to a situation which could have prevailed in the United Kingdom, England, and go back a few centuries. It is stated that there's good work by scholars who state that the participation of lawyers increased only mid-18th century. Before this mid-18th century, lawyers did not participate in trial proceedings, especially criminal trial proceedings. Their participation, if any, was limited to one of assistance. In fact, it is stated that before the lawyers' participation began in a bigger way, mid-18th century, the law on standard of proof was in a very nascent stage, was inchoate, not yet fully developed. When we speak of Anglo-American system, we essentially speak of adversarial system. And the other system, of course, is the inquisitorial. If we go back a few centuries before the mid-18th century, the scholars have again said there was a system in place in England, which is identified as altercation system. In this system, there was an accuser and the accused. Appointed judge or judges would go in circuit, nominated jury members would also investigate, examine the truth or otherwise of a complaint or a claim, and participate in the proceedings and return a verdict of either guilty or not guilty if it is a criminal case, and in a civil case, whether plaintiff should succeed or defendant should succeed. It is called altercation because the accuser on oath would accuse the accused of the culpable act. If the accused was accused of murder, the accuser on oath before the jury in the court conducted by the judge would narrate the circumstances of that leading to that culpability. He would examine witnesses who would also state what they know on oath. And the accused would, of course, get an opportunity to use mostly modern day contextual expression, rebut the accusation, but he would not be administered oath. He was used as an informant because the accuser would say he did this, he is guilty of this. He wouldn't be in a position to explain or give information from his perspective. Being on oath would lead to incriminating himself, and that was not done. It is in this context where the accuser on oath would accuse the person of culpable act, and the accused would get an opportunity to. It is said that they were at altercation with each other. Then the jury would decide, depending on what they believed could have been the truth. Now, did at this point of time, the judge instruct the jury on the finer nuances of burden of proof, standard of proof? Did the judge instruct the jury in a civil case to decide on the preponderance of probabilities, or in a criminal case, did the judge instruct the jury to decide on the guilt of the accused based on proof beyond a reasonable doubt? These are evolved principles as we have them now, but at that point of time, as I said earlier, they were in a very inchoate state, in their infancy. In fact, the scholarly work in this area tells us that The rule, the first of the principle, preponderance of probability, evolved as a reaction. The accused would be found guilty of a particular offense, and he would be, and there would be appeal taken to the appellate court. In the appellate court, the lawyers would argue, stating there were two conflicting versions, two versions contradicting each other, one by the accuser, another by the accused. And the jury have accepted one. This version could not have been accepted because it was highly improbable. The appellate court, if it upturned the verdict of the jury or the sentence, they would upturn it on the ground that the version of the prosecution or the version against the accused would not be, cannot be accepted as being probable. Because this would be a ground for interference in the appeal, the judges at the trial started instructing the jury to decide the case on accept that case if they found it to be probable. In other words, they would instruct the jury to accept the prosecution's case only if the jury found it probable. Now, if this is how the principle of preponderance of probability began, it is also said by many scholars that the other principle, burden of proof beyond reasonable doubt, did not simultaneously evolve with the first principle, that is the principle of preponderance of probability, but it began a little later with the jury being instructed by the judges to, in criminal cases, to decide against the accused only if it was established beyond reasonable doubt that he was guilty. This was because with the evolving law, the courts also started recognizing the principle that we know very well today, that let 1,000 guilty go unpunished, let not one innocent be punished for an offense which is not guilty of. So we have, if one were to study these kind of scholarly material, it would be to our understanding that somewhere in the mid-18th century, the principles of preponderance of probability in civil cases commenced, and almost thereafter, in a manner which could be called as a reaction and in recognition of certain rights of the accused, the rules of proof beyond reasonable doubt emerged. And over the centuries, they have been fine-tuned. And because we follow the Anglo-American system, we also have the same principles. I would like to dwell on these two principles, preponderance of probabilities and burden of proof beyond reasonable doubt. Evidence Act does not speak about, we have Evidence Act, and Evidence Act holds the field so far as we are concerned. And Evidence Act does not speak about in specific terms, speak about these two principles. Nor does it say that in civil cases, evidence will have to be assessed on the basis of preponderance of probability. And in the criminal cases, evidence should be the evidence that is required to find a person guilty is that it should be beyond any reasonable doubt. The root, however, to these principles is found in Section 3 of the Evidence Act. Section 3 sorry, just a minute. Section 3 of the Evidence Act defines, amongst others, fact, what is a relevant fact, what is a fact in issue, and it also defines what is a fact proved. A fact is said to be proved according to this definition. A fact is said to be proved when, after considering the matters before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. This definition essentially has two parts to it. One, where the court believes a fact to exist, then we say the fact is proved. Second, where the court considers its existence, the existence of a fact, so probable according to a prudent man in the circumstances of a given case, and act on the supposition that it exists. Then also we say that the fact is proved. So there is no, except this definition, there's no other provision which essentially speaks of these two doctrines. And if we look at this definition, the word that catches our attention in the context of a discussion is probable and a prudent man. The first part of the definition is if the court believes it to exist, which is apparently very easy. Second is where the court considers the existence of a fact so probable that a prudent man in the circumstances of a given case must act under the supposition that it existed. Now, this is what the provisions of Section 3 of the Evidence Act says. Now, when do we say the court could believe that a certain fact exists? Now, if you are speaking about a case, a criminal case where A is accused of committing the murder of B, when does the court say, I believe A has committed the murder of B? If it is a civil dispute and the dispute pertains to a contractual right asserted by the plaintiff and denied by the defendant, with the plaintiff saying, yes, there is a contract between me and B, and the defendant saying, no, there is no such contract. When does the court say it exists? The contract exists. There is the culpability of A of having killed B. Now, this is not very different from the second part. The second part is where a prudent man acts under the supposition in the circumstances of that particular case that, yes, this must have existed. There are three decisions that I would request you to go through in more detail. One is the recent one, the Ayodhya, popularly called the Ayodhya judgment. Their lordships have spoken about, in that have referred to Dastane versus Dastane, AR 1975, SC 1534, which is, and the other one is State of UP versus Krishna Gopal, that is reported in AR 1984, SC page 2154. The Supreme Court, as reiterated in the Ayodhya case, that a fact is said to be probable if it satisfies two tests. The tests are, as the definition mentions, as a prudent man, the court must feel that it must act under the supposition in the circumstances of the case that such a fact exists. Now, these are the two tests. to test the version as a prudent person, and as a prudent person who is compelled to act under the supposition in the given context of a case that yes, this could have existed. This fact which is in dispute, a fact in issue, could have existed. Now, I can relate to the expression baffling, mystifying when I speak these words. The words baffling and words used by Dr. Desai, because we are speaking, no, you must test us against the cornerstone of how a prudent man would act under the supposition that it would have existed in the facts and circumstances of the case. Now, what does it mean? Could this be reduced into a straightforward formula which could be applied? In fact, referring to seminal work in this regard, the Supreme Court in State of UP versus Krishna Gopal says probability or the degree of probability cannot be measured in terms of a unit, which could be mathematically applied to say that so many units would lead to a certain probability of the existence of fact. There's a clear enunciation here that there cannot be this concept of preponderance of probability, assessing whether a fact could have been on the basis of probability, cannot be taken, cannot be assessed by applying the rules of mathematics. We cannot say if there is 2 plus another 2, it is 4. The Supreme Court therefore has said, again referring to seminal work in this area by scholars, that don't look for that kind of mathematical application. In fact, the Supreme Court says it is inevitable that there be subjective element in assessing whether a certain fact could have been probable or could be probable or not. It is inevitable. A subjective element is inevitable, is what the Supreme Court says. Next, the Supreme Court says, firstly, it can't be mathematical. Secondly, subjective element is inevitable in evaluation of probability and the quantum of evidence. And in the ultimate analysis, the examination of probability must rest on common sense and on the trained intuition of judges. 3 points are being made here. 1, in our effort to demystify, in our effort to unbaffle ourselves in understanding the concept of preponderance of probability, we will have to be certain that we cannot look to any mathematical application or precision. We will have to reconcile ourselves to the fact that there will be a subjective element in the evaluation of probability and the quantum of proof. And ultimately, 2 factors will decide. That is the common sense, a robust common sense, and the trained intuitions of judges. These 4 will have to work while assessing evidence. Now, just to make the point, in cases where there are disputed facts, there are undisputed facts. There's no dispute at all for an adjudication. The adjudication comes about when there are disputed facts. If there are disputed facts, then the assertion is somebody is culpable because he has done something, or there is a particular right, either in law, which is denied, or there's a contractual right, which is being denied. Now, those disputed questions will have to be decided, and they will have to be decided on the scale of preponderance of probabilities. Now, when I began, I said, generally in civil cases, the veracity of a claim or the genuineness of a claim is decided on the scale of preponderance of probability. And in criminal cases, we decide on the scale of proof beyond reasonable doubt. And I said that one of the questions that could crop up is, are we speaking of two different rules? We could pause here for a minute and understand whether we are really speaking of two different concepts, one for the civil law and another for the criminal law. And while making a reference to the way these two principles have evolved, I also mentioned that in civil cases, because the appellate in criminal cases, because the appellate courts would interfere on the question of preponderance of probabilities, the judges will instruct the jury in England to decide whether a certain fact could be more probable than the other. In fact, it is settled, and it is being reiterated time and again, that these two scales, the scales of preponderance of probability and proof beyond reasonable doubt, are not two different scales really. Preponderance of probability is the same rule that is applied both in civil and criminal cases, but in criminal cases, a higher degree is insisted upon to find the accused guilty. And how is that higher degree secured? That higher degree is secured by ruling out reasonable doubt in the prosecution's case against the accused. In fact, it is articulated that if in civil cases, if one version is more probable than the other in the opinion of the court, then the scale would tilt in favor of that person who propagates or who canvasses the more probable version. And if it is equal, that it could be 50-50, it could go either way or this way, then no, it can't. It can't. One has to be more probable than the other. This is how the evidence is appreciated in civil cases. If both versions are probable, then a fact is not proved. If one version is more probable, then the courts will find that fact which is more probable, or that version which is more probable, as proved. If a dispute is of the kind involving dispute between A and B is of the kind involving whether there is a contract between them, with A saying there's a contract and B denying the contract. If the evidence is suggested that yes, there could be a contract and there need not be a contract, then that would not suffice. That would not suffice. That is not preponderance of probability. Preponderance of probability B should be, yes, the contract between A and B from the following circumstances is more probable. At this point of time, it would be, in my view, relevant to mention that a lot of importance is attached to the oral testimony. In fact, the Supreme Court has stated that the testimony of the witnesses would make the ears and eyes of justice. The witnesses who are privy to certain information, in the sense that they are familiar with that information, when they come and speak in the court, that is given a lot of importance. And this is called direct evidence. And then there is circumstantial evidence. There are no witnesses who can come and speak about A having committed a particular culpable act, but then different people are able to come and speak to a certain set of facts which lead to an inference or a deduction that yes, this fact could be. Now that is circumstantial evidence. If the witnesses come and speak about the culpability as having witnessed the culpable act, then that is given primacy. Until and unless the victim's credibility is undermined, then that account of the eyewitness acquires a lot of importance. In circumstantial evidence, the certain chain of events is presented as leading to or establishing a certain fact. In criminal cases, if circumstantial evidence will have to be relied upon, then there cannot be any room for doubt. If there is doubt about the culpability as spoken to by the circumstances, the chain of circumstances, then the accused is generally given the benefit of doubt. Now, we are speaking of doubt and we are speaking of reasonable doubt. I saw a question whether the strength of burden of proof determines the magnitude of the legal system's major negative. I would request Professor Tejas to sort of bounce this question later. But of course, this came up and was noticed by me. Now we speak about doubts. When a high witness accounts what he has seen as accounts an incident which he has witnessed, yes, his oral testimony is given a lot of importance, subject to the cross-examination. And in fact, the Supreme Court has said that a witness's account in the cross-examination should be given more credibility than what is stated in his chief examination, because the lawyer in cross-examining the witness, the eyewitness, puts him to the acid test. And if he was able to withstand that test, then that gains importance. An element of doubt is removed there. In cases where there is circumstantial evidence, then because it's a matter of deduction, if there is A and there is B and there is C, then please deduce from this that A is culpable of committing the murder of B or committing theft from B, is almost a deduction. And in the deduction, if there is any doubt, then we say the evidence is insufficient to establish the culpability. There is enough material to interest any student who wants to write a thesis on what would constitute doubt. The courts have said it should be a reasonable doubt. Then what is a reasonable doubt? When do we say there is a reasonable doubt? I would, for the present, refer to the decision of the Honorable Supreme Court, again in State of UP versus Krishna Gopal, which is also referred to in later decisions, including decision in Ramakant Ray versus Madan Ray, reported in 2003-12 SEC 395. It is said that the doubt must be, a doubt is said to be a reasonable doubt when there is no abstract speculation. The courts in saying whether there is a doubt or not cannot resort to abstract speculation. The courts cannot see a doubt because of an emotional response. The doubt must be actual or substantial doubt as to the guilt of the accused, and that doubt must arise from the evidence itself. These are the three rules that or the three guidelines that the Supreme Court has spoken of. One, the doubt cannot be an abstract speculation. Second, there cannot be an emotional response. That is, a doubt cannot be seen as an emotional response. Three, the doubt must be actual and must be substantial, arising out of the evidence itself. Now, at this point of time, just to sum up, when we speak of appreciation of evidence, we essentially apply two tools. That is preponderance of probabilities and proof beyond reasonable doubt. In fact, these are not two different rules. They both speak about the same, but in criminal case, to ensure that a person who is not guilty is subjected to some kind of imprisonment or a sentencing, we say that the proof against this person must be beyond a reasonable doubt. Because if we stop at preponderance of probability, we will be saying, if the court is of the opinion that there are two versions, one of the guilt of the accused, another of the accused not being guilty, one of the plaintiff asserting a right and the defendant denying it. If out of these two versions, based on evidence, if the court feels one is more probable than the other, then the court leans in favor of that. If this were to be the only rule, and if we were to stop at this place and move no further, then we could be, in criminal cases, holding a person guilty when he may not be guilty. And to prevent that, we apply another test to ensure a higher degree. And that is the second principle, that is proof beyond reasonable doubt. When we speak of preponderance of probabilities, yes, we speak of two things. One, the court in the circumstances of the case believes it to exist, or the court considers the existence of a fact because the court considers a prudent man would consider it as so probable in the facts and circumstances of the case, he would act upon such supposition. That the underlying word is probable. And two words actually, probable and prudent. When do we say a prudent man acts under the supposition that a particular fact is probable? We'll have to fall back on what the Supreme Court has cautioned us and told us. One, please don't expect mathematical precision or mathematical enumeration. There can't be so many units of this. Will add up to a probability of the probability of the establishing a particular fact. Second, subjective assessment is inevitable. Third, ultimate analysis. It will be the robust common sense and the trained intuitions of a judge. And now, when we speak of doubt, we speak always of reasonable doubt. And what is a reasonable doubt? Is that doubt which is not speculative, which is actual, and a substantial doubt arising from the evidence as regards the guilt of the accused or otherwise. And three, we do not see a doubt as an emotional response to a certain facts and circumstances. Now, I must, before I proceed further, say if this is the theory on the standard of proof or sufficiency of evidence, the Supreme Court has also given us a practical guideline on how these two principles are applied. I would refer to, as I mentioned earlier, Dastane versus Dastane. Here the Supreme Court has said the application of the rule of principle, the rule of preponderance of probability applies in two steps. And the court also says that these two steps could be intermingling and not necessarily be a watertight compartment. The first step, now I see this as a practical guide by the Supreme Court to the lawyers who need to present their case and the judges who have to appreciate the evidence and arrive at a particular conclusion. It operates at two stages. The first stage is where the courts will have to filter out the impossibilities. Now, A is accused of committing murder of B. At the first level, the court must necessarily see whether this is an impossibility. If this is an impossibility, then there is no second stage. Because it is impossible, the person is entitled to be declared innocent or acquitted of the accusation. The second is when we exclude the impossibilities, then we go to the second stage. In the second stage, we are left only with what are probabilities. Yes, A could have committed the murder of B. Now, in civil cases, we examine the different probabilities, and if a particular fact is more probable, then we lean in favor of it. In civil cases, if the probability remains only that, then remains that only despite applying the test of reasonable doubt, then a person is acquitted because the fact is not proved. But if the test is answered and there is no doubt, then the person is found guilty. So the Supreme Court says, applying the test of preponderance and thereafter the test of proof beyond reasonable doubt would essentially be three steps. First stage, exclude the impossibilities. Second stage, identify the probabilities. At the scene, a civil case, we stop there. In criminal cases, we go a step forward and apply the test of the proof beyond reasonable doubt, and that is where the third step is taken. Now, of late, the concept of reasonable doubt is also been considered of significance in deciding on the quantum of punishment. And that would make an interesting reading, and I would recommend those who are interested in knowing this in more to read the decision of the Honorable Supreme Court in Ravi Shankar versus State of ANP, reported in 2019 9 SEC page 689. Now, Professor Tejas, we are closer to the time allotted.
We can continue, sir. Questions. We have very few questions. So if you can spare us a little more time.
We'll take a few more questions and then come back.
All right, sir. So there are a few questions which are posed by participants. I'll take a few now. The first question is from Kalki. He is The question is, what is considered as permissible hearsay evidence? That is a question. What is considered as permissible hearsay evidence?
Is hearsay evidence permissible? Is a question.
Yeah.
No, hearsay evidence is not permissible. It is a account of a person. Generally speaking, hearsay evidence is not permissible. Hearsay evidence is evidence of somebody telling me about this. It is not generally permissible. But of course, there are exceptions. We could generally refer to them as confessions, even called extrajudicial confessions. But general rule is hearsay evidence is not permissible because the person who is giving the evidence is only relating what has been reported to him and not what he is a witness to. Therefore, it is impermissible. And of course, the exceptions to that would be confession or even extrajudicial confession.
Right, so then the next question is from Professor Uday Simanji. Now his question is whether the strength of the burden of proof determines the magnitude of the legal system's major negative consequences aside from direct operational costs, namely erroneous assignments of liability. I'll repeat the question, sir. Whether the strength of the burden of proof determines the magnitude of legal system's major negative consequences aside from direct operational costs, namely erroneous assignments of liability.
In fact, I've come across certain scholarly work on this topic. Now, the criticism of the burden of proof is that, in fact, they say it leans in favor of the wealthy because not everybody can muster the resources to summon that kind of testimony or source that kind of testimony or get the people to place that evidence. And this actually skews the system in favor of those who could be termed wealthy. They say this is one of the drawbacks of this burden of proof that is applied. And therefore, it is said as a negative consequence. But then the advantage of this rule is that before we get into a conflict, we know what are the responsibilities that we are taking upon in an adversarial system. If I go to the court in a civil dispute, if the burden of proof, the law of burden of proof is clear, then it becomes easy for me to know what I'm taking on and what I'm required to establish before the court if I were to succeed. Now, this is a major advantage. And the disadvantage in terms of wealth playing a role in the ability of a person to source the evidence, or not, when we say source, gather, nothing more, gather evidence, then it would be mostly in a case where the state has a role to play, that is criminal cases. And investigation is conducted at the cost of the state. And with major roles now being provided for by the complainant. And to that extent, I would say the negative of this rule is being vastly mitigated now. But of course, this is a matter for further discussion and see how the laws have evolved.
All right, sir. Thank you. The next question is from Professor Preeti Desai. A question is, what do you think is the purpose of evidence law read with criminal law? Is it to arrive at the truth or to render justice?
That's a good question, because this has been of some intrigue to me as well as a student of law. Now, I've always seen this question or this topic from the lens of the system being either adversarial or inquisitive. In inquisitorial system, the judges play the role, so to say, of an investigating body as well. They probe, they drive, they get to the truth. In the adversarial system, the judges play mostly, as they call, the role of a referee, an umpire. Two versions are placed, and based on appreciation of evidence, a certain fact is accepted as truth. Now, which one is to be preferred? Well, we have chosen one, is what I would say.
All right, sir. Thank you.
I hope this answers Madam's question.
Yeah. Now, the next question is from Navina Nitin. Her question is, how do the courts measure the gravity of evidence in encounter matters? I'll repeat the question, sir. How do the courts measure the gravity of evidence in encounter matters?
I would look at this question in two parts. How do the courts measure evidence? And how do the courts measure evidence in encounter matters? Is there a difference? Should there be a difference? Is how I would address this particular question. There is no law which says in matters of encounter, we will apply a different measure to assess evidence. In current topic, I mean, in what is in news now, yes, this question resonates, but I would say the scale for assessing evidence in encounter matters should remain the same, would remain the same as in any criminal case. In an encounter case, the accused would be the investigating agency, which is held responsible for the death of the person. Of course, their defense would be that this was done in a particular circumstances, how much that should be believed, and all that is again to be assessed, applying the same rules of evidence. And until some lawyer comes before us and argues why a different set of measures must be applied in cases of counters, as of now, we would say the same measures should apply.
Thank you, sir. The next question is from Vishnu. His question is, considering a few controversial legal cases these days, can we say that presumption of innocence is missing in our legal system?
Now, this is a very good question, and again, a topic for further study. And of course, some strident decisions are now available for our understanding. I refer to the basic rule in criminal law that let the 1,000 guilty go unpunished, let not one innocent be punished. Now, the courts have said, and rightly so, that in our zealousness to apply this law, we may be forgetting the rights of the victim. Victims also have certain rights. It should be available to them to say that the guilt must be brought to books, made accountable, and punished. So depending on what the society and the legislature feels are those laws, those areas where presumption of innocence must be diluted, it is diluted. We can readily speak of Section 113A, Section 114 capital A of the Evidence Act, with 114 capital A being newly brought in. That in rape cases there shall be presumption against consent. Now, this is progressive, and in the ultimate balance that we have to strike, there can't be an overleaning in favor of one. We must balance. And if presumption of innocence of the victim is one of the scale, the other scale would also be of the rights of the victim. And in this, there needs to be a balance.
So this being a very interesting topic, we're getting a lot of questions. Now I request you to spare us a little more time so that you could answer all of them. Can may I request
Please,
you, sir,
please, please.
can we take them? Thank you, sir. So the next
Please,
question
sir.
is from, Madiha. Her question is, even though such a bifurcation exists, a problem might crop up in the form of criminal charges within a civil case. What is the standard of proof when a civil case is also criminal in nature?
Now, I find this question interesting. In fact, there's a decision by the Honorable Supreme Court. I'm not able to get the citation right away, recollect from a memory. This question is relevant in the context where fraud is alleged by one of the parties. Now, fraud, by the very nature, is we could say, must be punished, must be penal. The Supreme Court has said, even in cases where fraud is alleged, the courts must apply the scale of preponderance of probability. But in applying the scale of probability, the court must take into fact that the person who is accused of having committed fraud will have acted in good faith. This is what is the caution. Yes, here is a person who is accused of having played fraud and taken an advantage to himself, having played fraud on X and taken an advantage to himself. And when that is set up as a defense in a civil case, again, we apply the same rules of evidence, preponderance of probabilities, standard of proof. And in applying these principles, the one thing that we need to remember, as the Supreme Court emphasizes, is that the person who has taken an advantage, according to the person who's accusing, could also be acting in good faith. When the circumstances placed before the court are assessed in this context. Now, to go back to the other question, are we seeking out the truth, or are we deciding on a certain fact that is decided? I would answer that question by saying that yes, we apply the test of preponderance of probabilities, but we also, when we apply, we have to bear in mind that the person who's accused of having played a fraud could have acted in good faith. If the circumstances suggest otherwise, on the scale of preponderance, we will hold a person is guilty or otherwise of fraud in a civil case.
Thank you, sir. The next question is from Priyanka. Her question is, how will the court appreciate evidence when there is an inconsistency in the date of birth of a person, as it is different in the birth certificate and their board examinations mark sheet? So I'll repeat the question, sir. How will the court appreciate the evidence when there is an inconsistency in the date of birth of a person, as it is different in the birth certificate and their board examination mark sheet?
Now, we have got, insofar as Karnataka, we have got a specific enactment, and we have certain rules for government employees in this. I would generally state, without going into those provisions, because no off-the-cuff kind of a remark, yes, the board examination details are attached importance, but if those will have to be overturned, then what is significant is that the right measure is taken at the earliest and not at the fag end of one's career if one is in service. And if the person is not in service, then at what stage the person takes the appropriate proceedings for vindication of the age as it is true than as is mentioned in the birth certificate. This is to say, yes, the birth certificate, the board certificate will have a primacy, but subject to a decision of the court or the appropriate authority in accordance with the relevant law.
Well, the next question is from Dr. Vishnu Prasad R. His question is, appreciation of evidence can be subjectively done by the judges. Can we say that the law of evidence is adequate to remove judicial subjectiveness?
Good question. I would again go back to what His Lordship Justice M.N. Venkatachalaya said in the State of UP versus Krishna Gopal, and which has been reiterated as illuminating a decision by the Honorable Supreme Court in the subsequent decisions, and is in fact referred to by the recent full bench, with the constitutional bench, larger bench in the Ram Janmabhoomi case. It is the element of subjectiveness in appreciating evidence is inherent, because there can't be a mathematical uh, application or enunciation. But having said this, the element of subjectiveness is actually the room for subjectiveness is actually reduced by the emphasis on the context or the peculiarities of a particular case. So the court can be subjective, will be subjective, but then it will have to take into consideration the peculiarities of the case. And that is something which circumscribes and reduces the play for subjectiveness.
There are three more questions, sir.
So the next question. This I would subject to the scholarly work that would come up in future, and the lawyer's assistance as in the growth of the growth of law in this area. I would say at this point of time, the emphasis on the courts to exercise, to make a subjective evaluation within the contours of the particularities of a given case would be adequate, is what I would say. But then one of the senior lawyers, when I began practicing, and I asked him, "Sir, what do you achieve? What do you want to achieve now that you put in 35 years? You have all these successes. What do you want to achieve in your career?" And the senior counsel, very respected member of the Bangalore Bar, said, "Push the law an inch in any direction. That would be my goal." So I'm sure the lawyers would push and tell us that this is adequate, maybe a little more to make it more adequate. Yes, sir.
Yes, sir. Thank you. We have three more questions.
Go ahead, sir.
Okay. Now, the question is from Professor Uday. His question is, does the usage of grammatical notations like shall, presume, and may presume used in the Evidence Act causes unnecessary confusion? Is there a rule of thumb to use shall and may?
Oh, that's a topic for another complete discussion, Professor Uday. But in the context of what we have discussed, I would only say this. In civil cases, your question is mostly in the context of presumption, may presume, shall presume. But I would give it today's context and say, insofar as the appreciation of evidence is concerned, in a civil case, if the court can deduce, not presume, deduce with the assistance of presumptions, different presumptions available in the Evidence Act, to come to a conclusion that guilt of the accused is established beyond reasonable doubt, then there is a reason for convicting a person. And similarly, in a civil case, if the court, on a scale of preponderance, could conclude that something is more probable and take assistance of all the presumptions that are available, Section 114 of the Evidence Act, then in a given context, 114A of the Evidence Act, Section 138 of the Evidence Act, 118 of the Negotiable Instruments Act, 138 of the Negotiable Instruments Act. Now, I would say it's a topic for a complete discussion on its own.
So the next question is from Manaswini. Her question is, between the documentary evidence and the contrary admission of party in cross-examination, which would prevail?
I would ask you, madam, to pay attention to Section 1991 of the Indian Evidence Act. One of the fundamentals is that a document is the best evidence of the contents of the document, and no person can be permitted to plead evidence to the contrary until unless the exceptional circumstances provided for under the Evidence Act is made out. So, question of primacy, yes, the Evidence Act says if it's a documentary evidence, then the document would have primacy over testimony, oral evidence, oral testimony, that is.
Thank you, sir. I think we'll take up the last question from Chandrasekhar. Is it not the delay in trial will dilute the veracity of evidence? Can't the Evidence Act do something in this regard?
This takes us to block one, as they say. And I would go back to what Dr. Sandeep Desai said. Is evidence law substantive, procedural? Is it procedural and substantive, or it is substantively procedural? Now, these questions have a bearing. These questions have a bearing in saying whether Evidence Act could be tweaked to make it, to make our justice dispensation quicker. Yes, delay does give an impression that justice will be buried because it would be difficult to sustain evidence. And I would only say that and see what will come up in the future on this.
So we are getting a lot of questions. So I think we have one more question. So if you could spare a little more time in answering that question, I think I'll take that up. Otherwise,
I'll be brave. I'll take one more.
Thank you, sir.
In fact, one of our senior lawyers said, if at the end of our talk, if no questions are asked, then the presumption to the speaker could be that he has convinced everybody or everybody has gone to sleep. And if there are too many questions, the conclusion could be that either the speaker has evinced interest or there is so much of difficulty that they want to ask too many questions. Either way, it's okay with us. So go ahead.
Yes, sir. The next question is from Maya. The question is, sir, in the case of rape, if there is a delay in reporting of the crime and there is no possibility of direct evidence to be put forth, will the case be judged only on circumstantial evidence?
When we speak of evidence in rape cases, let us speak of the evidence of the prosecutrix itself, if she could come and speak. If she cannot, for whatever reasons, including that she's put to death after the commission of the efforts, then because the prosecutrix is not there to give evidence, or there is no eyewitness, because generally saying, you can't expect a witness to a rape occurrence. Now, then circumstantial evidence will have to come into play. They are taken into consideration. And that is where Section 114, capital A says that in those cases where there shall be no presumption of consent and things like that. But if there is, the next part of the question is, if there is a delay in reporting the crime, what would be the consequence? No, the mere delay in lodging a complaint cannot be of any consequence by itself, because the prosecution may be able to justify the delay in lodging a complaint. In fact, the Supreme Court has said that in the context of a poor woman was assaulted sexually, it, in the context of a society, takes a lot of courage to come out and lodge a complaint, perhaps also face stigma thereafter. So delay in the complaint by itself cannot be a circumstance that could be relied upon. Of course, in a given context, that could be one of the circumstances. That is how I would respond to this.
Thank you very much, sir, for such an interesting talk and giving us an excellent coverage on the topic law of evidence. Now I request Professor Pramod to propose vote of thanks. Over to you, sir. Pramod, sir.
Yes, sir. Thank you, Professor Tejas. Good evening, everyone. I, Professor Pramod, deem it to be my pleasure to vote of thanks on behalf of Faculty of Law, PESU University, Bangalore, this evening. I profusely thank Honorable Justice Shri Shyam Prasad, Judge, High Court of Karnataka, wondering the impeccable lecture on appreciation of evidence with respect to burden of proof and standard of proof. Sir, we are indebted for your presence in this webinar. I thank all the participants for actively participating in the PESU webinar series. I thank Dr. Sandeep S. Desai, Dean, Faculty of Law, for his constant guidance and support. I thank my colleagues, Professor Tejas, for moderating this session. I thank Professor Ranjit and Professor Uday Sima for their constant efforts to make this webinar a grand success. A special thanks to the management of PESU University for their constant support towards Faculty of Law in all our endeavors. Thank you, one and all.
Thank you. Thank you.
Thank you, sir. Ladies and gentlemen, I thank you for your active participation, and I hope you enjoyed this webinar. I hope this was a wonderful evening, and stay tuned for more webinars that we are hosting in this webinar series by Faculty of Law, PS University. Thank you very much. See you guys in the next one. Bye-bye.
Thank you, sir. Thank you, everyone. Thank you, sir.